So start live. Okay, good morning, everyone. If I'm audible, let me know. So we are audible? Okay. So today's lecture would be technically the beginning of the polity or the constitution. We have discussed about the basic concepts, right? We'll start with the state. Obviously, state, uh, whether it is Indian state or any state, has a political feature. It has a political identity. And this political identity revolves around certain features. So whenever a territory or an entity is called a state, it has some defining features. Most of you might be knowing about the international law definition. Fine. Uh, the idea of constitutionalism, okay, rule of law, rule by law, right? Dicey's view, okay, basic concepts that we have talked about, fine. So we'll start with this today. State. So any system, when it is called a state, it has certain features. As international law has to recognize any political territory as a state, then it needs to have certain conditions fulfilled. State is a legal or a formal status which any country or any political territory enjoys with respect to the other nations of the world. It is also a kind of international recognition uh, in the community of nations across the globe. Why it is mandatory? Because unless an entity or a territory has the status of a state, right, it will not be able to conduct its affairs or its interaction with the rest of the world in that manner. And that is why this identity or this idea is important, right? So what features that a state has? Now, when we say use the word, we use a state which is legal, and we use a nation, right, or a country. Now, these two are generally informal terms, right? A country is more related to the territory part. It's more related to territory part. Nation is related to cultural aspect, right? Every nation, every society is different. So the word nation is mostly influenced by the idea of society or culture, right, or civilization. So the civilizational values, whatever be it, culture, aesthetics, art, religion, clothing, language, and many other identities which comes with a civilization will be part of that. Territory is more of a geographical idea, right? So geographical entity. So that gives us more of a country, people living together in a geography. Right? State, on the other hand, is a legal term. This legal recognition is obviously provided by an entity which has already been considered internationally recognized, right? For example, United Nations. So United Nations recognizes under the international law. Right? So what do we have under the international law which recognizes the states that fulfill the criteria of that international convention? Right? Like for example, United Nations. These are some universal characteristics. These may be distinct characteristics, right? So these are very distinct characteristics or typical to that particular territory, whereas these are, you can say, the universal characteristics. For example, you need to have a defined territory. All these features must be present simultaneously, right? Not exclusively. It's not that one is there, so it is no. They have to be simultaneously present and not exclusively present. Defined territory. Obviously, your geographical boundary must be defined. Defined population. This helps us understand technically your citizens versus aliens. Right? They can be both friendly and hostile. So define population. It helps us understand the rights and duties and obligations of a state with respect to its population. Right? Then you have sovereignty. Obviously, sovereignty, as we have talked about, right, will be both internal and external. Then you have rule of law, right? A well-defined justice system, and somewhere a stable government, acceptable form of government, right? So that is also one aspect. It can be generally a democracy or a symbolic monarchy or a presidential form or parliamentary form. It can be any form. But generally, the preferred form is democracy. If these features are inter alia, right, along with them, right, they are all inclusive to each other, then you define a state, right? So, state in general, which was defined in a more negative manner, right? Normally, the state is defined as a system of authority. So, somewhere this definition puts one part, authority, only as one of the characteristics of the state, with along with the other aspects, right? So, this definition itself creates an obligation on something called the state to serve its people. That is why you have to define population, right, distinctly in this definition, right? So this is like a modern definition of state. In general, as you know, state is a political entity, right? It is the symbol of power in a society, and generally it is born out of a contract, right? Otherwise we can take state traditionally also emerging from the divine intervention, right? As we have talked about, that states generally reflect the characteristics of society. But there was a time when state was considered to be something born out of divine intervention, monarchical states, right? And they were also kind of legitimate states. But obviously, they did not have the features which are desirable under the international law today, right? So you have this definition, right? Then, so state, as per definition, state in general is abstract term. State is a system of authority. It is symbol of entire power. You can use the word authority also, it's okay. Entire power of the society. Right. State is different from government, though for normal purposes we use the term state and government interchangeably, though it is not, right? State comprises of all the entities which are there as part of the system of governance, right? State also includes citizens, no doubt about it. Fine, we have already seen. So state, so they may ask questions like this, okay, state in the context of India, when we use the word state, right, it is defined under Article 12 and also defined under Article 35 or 36, you can say. 36. Fine. But main definition of the state comes from Article 12. This is done for the provision of fundamental rights. Right. Why defining state becomes important? Because definition of state helps us understand, right, to whom the power belongs. Right, to whom the power belongs and who is responsible for the functions of the society or who is responsible for governance. So Article 12 that defines the state. Now when you see in the context of India, right, the state is federal or unitary. It can be federal or unitary the way it governs. It can have different format, right? So Article 12, right? How does it define the state in India? Or technically, what is that state, right? Which constitution tends to define as per the Article 12? What is that state? Union legislature, union executive. Right? State legislature and state executive. All forms of local bodies, which obviously includes the administration as well, right? It's not just the executive political part, it's both. So you have union government, state government, local government, right? That's very clear. Then you have any other body recognized by the parliament. By law. So any other type of body which may be recognized by the parliament by law, right, will also be the part of state, right? Now these three aspects are quite clear, but this is the discretionary aspect. So question may come that, so clear लिख देते हैं. Question may come that under the definition of state, right, the any body right, apart from the union, state, and local government, can be declared as a public authority or a state duly recognized by the parliament. So, who has the power to recognize any authority as a state or as part of the state? It is parliament, union legislature, right, not the state. Also, when you say this aspect of defining anybody as part of the state or anybody as time being working as a state, right, it is a kind of discretionary power. So, one aspect, union legislature can define it. Second, it is discretionary in nature, right? Can private entities be defined as public authority? Yes, they can be for time being if the parliament makes a law, right? Public-private partnerships, they can come under the definition of state if there is a law which is made, though it has not been done, right? PSUs become part of the state even though they are not technically the directly part of the state, but they become part of the state because government has ownership in the PSUs, right? So likewise, they can be right. This is also very important to define the state, why it is needed, obviously to enforce the fundamental rights, right? To make the entities accountable for their actions, right? Then it is also very important to think of these as to implement certain laws, right? Their obligations towards the citizens, like RTI. So when you say RTI defines state, right, or any law particularly talks about the rights or privileges of citizens with respect to the state, then obviously that has to be defined, right? So example like RTI. Now try to understand, we will not be studying in usual way. Why? Because that is the method of the dumps, right? So wherever we need information, we'll keep adding it, and that is how you should remember. Only then you can remember. You cannot remember in one line, in a sequence, right? One ये होता है, two ये होता है, three होता है, ऐसे नहीं याद होता है, right? याद करने का method है कि it should be always integrated. So why we have to define? Because there are certain reasons for it, right? Now, see. When you define the state or when you clarify what is the state, right, then you also achieve one more purpose. What is that purpose? An important purpose. No, it will come under law. That is fine. ये तो हमने लिखा है. What is the other benefit? Right? You will also establish the role of judiciary. Fine. Now, when you are defining a state in Indian context, obviously you are not using the word judiciary here, right? So why Article 12 now does not include the judiciary? Why does not include judiciary? Now that is a very important question. Which you should have asked, that why we did not include judiciary in this. When we take normally the state, right? Think about it. When we take normally a political system, a state, right? We talk about the organs of the state. Even Constitution has defined in detail the organs of the state. So we have legislature, executive, judiciary, right? Why here we have not taken this into account? So let's say a question comes, why Article 12 does not include judiciary in its definition? क्यों? पहला, because the definition under Article 12, right, is incidental to, it is related to the enforcement of fundamental rights. Against whom you can have the enforcement of fundamental rights? Against those institutions who make laws and implement laws. If you understand it logically, there is a hidden executive power with the legislature also. It can enforce things, right? It sets in motion the no confidence motion. It criticizes the government. It technically reviews the audit report of the government, right? So see, it has executive powers also. So laws, implement laws, make laws, right? Obviously, what kind of function is this? This is a function of authority. What kind of authority? Executive authority. So you have to enforce fundamental rights, obviously, against whom? Against the legislature and the executive both. Article 12 में दोनों है ना भाई? The fundamental right is protected from both. That is legislature as well as executive. Right? That is why we use the word कि भाई the laws should not be ultra virus. So the law which is made may negate fundamental right. The one who implements it may also negate fundamental right. So sometimes law may be inconsistent, sometimes the action may be inconsistent. You are getting it protected. So this is important. This is important. They have executive power. Obviously, judiciary does not have executive power, right? See, then there must be, or there is inherent idea of judicial review. So it is also quite obvious that we have a provision for judicial review. And this will be obviously done or is possible when judiciary is treated separately from the other organs. So that is why we talk about independence of judiciary. So when state is defined in general, judiciary is part of that. When state is defined specifically with respect to the rights of the citizens, with respect to the obligations of the state, right? And that is why there we don't define judiciary. Even though judiciary is also part of the state, right? Now, so judicial review may not be possible if it is part of the state, right? So we use it separately, right? D. Is judiciary involved in policy? No. That is also the reason, right? Judiciary cannot implement, neither can make laws or make policies. It does not have the machinery to do it directly, so it does not come under any obligation, right? Whenever it concerns or whenever it relates to fundamental right implementation part, it does not come under any obligation. So it will be illogical to define judiciary under this. We also need an unbiased system to protect our rights, right? So we don't define it, but still state exists or state is defined under Article 12, right? Fine. So state, right, for many other reasons, we have to define the state under Article 12, right? Fundamental right is one of them. Another reason is that whenever there is a conflict between citizen and state, the state has to take up the responsibility, right? Or it may be the state may be directly trying to intervene into the rights or privacy of the people, right? So for that purpose, we have to demarcate the ideological definition of state from the practical definition of state. That is what Article 12 is. The ideological definition of state will include all of them. The practical definition of state will not include them. For example, Article 300 now. Right, Article 299.
What about the judiciary's administrative capacity? Will that come in the
Which administrative? It has administrative functions with respect to its internal system only. It has no administrative function with respect to citizen. Fine. It has to maintain its administrative system within itself. So that is a purely administrative function at the organizational level. Right? When it comes to policy law, that is why we wrote it. No? तो पॉलिसी लॉ कोई और एक्सटर्नल फंक्शन है जुडिशियल कोई रोल नहीं राइट डायरेक्ट इवन एडमिनिस्ट्रेटर्स आर एम्प्लॉयड अंडर द जुडिशरी राइट फर्स्ट क्लास मजिस्ट्रेट जजेस जिनको जज नहीं बोलते उनको मजिस्ट्रेट बोला जाता है दे आर एम्प्लॉयड अंडर जुडिशरी दे आर परफॉर्मिंग दोज एडमिनिस्ट्रेटिव टास्क so government has a role with respect to judiciary right but judiciary does not have direct role with respect to government फाइन एग्जीक्यूटिव में जुडिशरी का रोल नहीं है जुडिशरी में एग्जीक्यूटिव का रोल है बजट बनाना फाइन इंफ्रास्ट्रक्चर डेवलप करना दैट इज देयर बट जुडिशरी का कोई ऐसा डायरेक्ट रोल नहीं है फाइन इट इज टू मेंटेन द सैंक्टिटी ऑफ द जुडिशरी आर्टिकल 300 to 99 right this relates to the tortious liability of the state right that state can be sued and can sue just like a person or an individual. So under what conditions, right? Under civil liability. Right? For criminal liabilities, obviously state is not directly held responsible. For civil liability with respect to any citizen, any group, any entity, any corporate, anything, the state can be sued like ordinary persons or citizens. Fine? That is called tortious liability. Right? For civil wrongdoings of their public servants, right, of their administrators, the state can be sued, right, like any normal organization. So when a mistake is done by, let's say, a bus driver, DTC bus driver, right, he kills someone. Now, obviously, that is a criminal act. There, the responsibility of that individual driver is created, right? But if someone's, let us say, boundary wall gets broken in the process, then it is a civil liability, and state will be held responsible with the driver. That time, the driver will not be treated as independently, right? That is called vicarious liability. Okay, so the employer, ये private के लिए भी use होगा, employer to be liable for the acts of employees. To be liable for the acts of employees. So definition of state provides us with lot of benefits, lot of limitations also, right? Because when there is one aspect of the state which is not defined, then it creates again a problem that an entity which may not be performing actual state function, like PSUs or banks, they may not be performing exactly state function, right, or sovereign function of the state. They might not, or many times their liability might be reduced or it must be diluted because of the definition under which they don't fall. So many times these entities have benefits because of the lack of definition. But as many of them are incorporated by a statutory law, by an act of parliament, they automatically become part of the state. Fine. इतना part clear है? Fine, clear है, then you write a question. Right. Assertion. The definition of state is necessary. Create its obligation towards the citizens. The definition of state is necessary to create its obligation towards the citizens. The contractual nature of state right. You know the usual options A, B, C, D. Right. The definition of state is necessary to create its obligation towards the citizen. Statement is correct. Fine. Second statement. The contractual nature of the state makes it mandatory to establish state-citizen relationship. Fine. ये भी correct है. Independently, both are correct. First, that should be established always. That whether these statements are independently correct. Right. Now, is the second statement the reason for the first? Think. Have you thought about it? You tell me, is it correct or not? Correct. Both here are individually true, right? R is the correct explanation of A.
Because it is talking about the citizens state relationship and that is talking about definition of state. तो उसका reason is
ये तो
basically
डिफाइन करना तो जरूरी है ना. ये defining it is important.
yes sir.
Why? Because it can create the obligation. Otherwise, how the obligation will be created? Fine. But is definition the only basis of obligation? No. Right? The contractual nature of the state makes it mandatory to establish state-citizen relationship. Contractual nature है, उससे क्या होता है कि स्टेट सिटीजन रिलेशनशिप डिफाइन हो जाता है. ये इंडिपेंडेंटली करेक्ट है, ये भी इंडिपेंडेंटली करेक्ट है. इफ वी आर डिफाइनिंग इट और इफ वी आर एस्टैब्लिशिंग अ कॉन्ट्रैक्ट, right? You're establishing a contract. So in that contract, what is or why we are establishing the contract? Because there is something which has to be written, something has to be defined. So what is this contract about? This contract is about the nature of relationship. Fine. So if this nature of relationship has to be established, then what is necessary? The definition of the state. So can you put it here and put it there now? You make reason assertion and assertion reason. अब करके देखो. You make the reason assertion and make the assertion reason. वही ये कॉन्ट्रैक्ट बना तब डेफिनेशन की जरूरत पड़ी ना, कि डेफिनेशन की जरूरत पड़ी इसलिए कॉन्ट्रैक्ट बना. So it's very logical that you have a contract, the contract defines it, and probably the reason for defining it is what? That the definition of state will create obligation towards the citizen. सो इस रीजन की वजह से ये कॉन्ट्रैक्ट बना. The definition of the state, right, is the reason for the assertion that contract was established to create the obligation or liability of the state or create a state citizen relationship. How and why this relationship was established? Through a technically a definition, or definition of the state was given just for this reason only. तो इसको हम डिफाइन करेंगे तो ये बेनिफिट होगा. दो ऑप्शन जो है, सबसे बेस्ट ऑप्शन जो है इसका क्या होगा? ए, नहीं ए नहीं, सॉरी बी. व्हाट इज बी? नहीं सॉरी, नो नो, सी सी सी. बोथ आर करेक्ट independently, because there does not seem to be a direct correlation, right? Or at least there is a correlation, but both seem to be an explanation in their own terms, right? दोनों independent explanation लग रहे हैं, right? Not necessarily reason. ठीक है, लेकिन when you see the final point, you'll understand कि भाई definition of state कहाँ पे आएगा? कॉन्ट्रैक्ट में आएगा. तो कॉन्ट्रैक्ट नेचर ऑफ स्टेट मेक्स इट मैंडेटरी टू एस्टैब्लिश स्टेट सिटीजन रिलेशनशिप. ये स्टेटमेंट असर्शन इंडिपेंडेंटली ठीक है, राइट? डेफिनेशन ऑफ स्टेट इज नेसेसरी टू क्रिएट. सो इस कॉन्ट्रैक्ट में क्या किया जाता है? इंपॉर्टेंट थिंग इज कि डिफाइन द स्टेट. सो रीजन व्हाई वी आर डिफाइनिंग द स्टेट, राइट? और स्टेट इटसेल्फ इज, और definition of the state is the reason so that we can establish the contract. Reason is not appropriate for the assertion, correct? That is why we are saying both should be treated independently. Fine? Most likely correct होगा, तभी भी बहुत, बट ये चेंज हो जाए और ये यहाँ जाए तो more or less correct. Fine, because these questions are not factual questions. ठीक है, ये factual questions नहीं है. That is why you have to follow a method in these questions, right? Interchanging the place, first viewing them independently, right? Then finding the basic theme of one statement and the another statement. So if you can add cause-effect relationship to the basic theme, then you can make it correct. तो 10 में से 5 में से 3 में से whatever, right? 50% तक correct किए जा सकते हैं, unless obviously you know the facts, right? Unless you have practiced a lot, so you can understand how the UPSC tries to bring these statements. ठीक है, तो उसका भी एक reason होता है, उसका भी एक method होता है कि कैसे tail word end हो रहा है, वहां पे tail word, वहां पे जो beginning term है वो कैसे शुरू हो रहा है, यहाँ पे tail word कैसे end हो रहा है. So always you can do that simple, it's a common sense method, but it may not always be correct. Because sometimes the reasons which are given are highly implied, they are not direct reasons. Fine. So it's not like comprehension. Even in comprehension today, they are asking questions which are very implied. Right? Generally, comprehension is done when we look at the comprehension independently, rather than looking at what we know. We just want to read the comprehension and find out what comprehension is saying. मुझे क्या पता, उससे कोई मतलब नहीं है. But today they are not asking it directly. That is why, again, the problem. So what is mentioned in the comprehension and what you can infer from the comprehension, both are needed now. Right, fine. So let us move. So India में जो है now, when we look at the constitutional structure or scheme of India, right? So we have, like we said, we defined Article 12. Now Article 12 is obviously for the purpose of fundamental rights and others. Okay, Pooja, we'll talk about the doubt. Don't worry, keep it. Right now, fine, we'll deal with this over a period of time, historical developments. There are some specific questions which are asked from here. Both your history and polity both can deal with it. Right? When you think of modern history, that can also deal with this political developments in India. Right? When you think of polity, that can also deal with it. but the nature of questions will not be, or we cannot distinguish between them. So historical developments will deal over a period of time, don't worry. जहाँ जहाँ जरूरी होगा जैसे civil services, fine, so we'll deal with the historical developments. In general, when you think of the British impact or the Mughal impact or the previous developments, so the concept of constitution obviously was not created, right? Mughal administration, did we have concept of constitution? Right? Religious instructions, right? Or theocratic norms, traditions, values, book, जो भी आप बोल सकते हो, and Shariat law, whatever. They had been the basis of the emergence of the legal or political system, right? Obviously, this was based more on the personal laws. Constitution, even though is a modern concept, the Britain already had its own constitution. So when the colonial rulers come, right, obviously a tradition-based, a religion-based control decline, right? Now try to understand when we talk about a religion-dominated control, a religion-dominated system, and another system which is mostly based on impersonal laws. Now one system that is, let's say, the British, based on impersonal laws, and this Mughal based on personal laws, right? Which would be superior, which could sustain for a longer period of time? Obviously, this can sustain. So one thing you should understand very clearly that Britishers, no doubt, whatever they did, they established a system of impersonal legal system, right? How they acquired the Farman, how they created the factories, right? Ultimately, why did they create a full-fledged legal system, Office of Collector, right? Or the Charter Act, or Regulating Act, Pitts Act, right? And then later Charter Acts, and then Council Act, whatever they did, all that was done obviously first to overcome the influences of these personal laws. Many developments were taking place, no doubt, right? One of the key aspect of obviously the British impact has been the centralization. Very near, I'll take you to very near things like 1919 Act actually dominated the Union government functioning in spite of the 1935 Act. The 1935 Act, which talked about federal system, and 1919 had a centralized feature. In spite of 1935 Act coming, obviously it was never in force, but still, the special provisions for the provinces, for the states, they were there, right? Where they could have enjoyed autonomy with respect to local functions. But then also, this dominated the Union government. So Britishers never wanted to leave that power of the Governor General or Viceroy or Secretary of State, whatever you say, right? Even though they were ready or willing to dilute the power of the governor. But in any case, right, in 1935 Act also, when they tried to create a federal system, this can be called as an effort towards decentralization. So 1909 and 1919 Act, where centralization was the key feature, right? Even though they accepted that they are going for political reforms, they did not do it. 1935 Act was a consequence, was a product of the continuous struggle of Gandhi once Gandhi comes to India, 1915, right? And then they initiated this decentralization. In spite of that, they never had intention of decentralization. So union government still dominated. Governor General still had power. Governor General's executive council had dominantly nominated members, right? There was no, they were mostly official. There was no political, local, native representation in those bodies, right? So they were willing to give little autonomy to the provinces, but not to the union level. They did not wanted to accommodate Indians into the union level, right? Now, see, you can understand this logic. Because of these, the conflicts started. This never came into picture. As you know, the princely states were given autonomy not to join it. Obviously, that was creating a threat to the existence of this country itself, right? They were given a lot of freedom, and they had biasness towards the British government, towards the colonial administration, because they were enjoying almost equivalent status with them, right? So this, so to overcome this drawback, right, they came up with the India Independence Act 1947, right? Or they established the Constituent Assembly, which again they had to break it into two, and ultimately they had to go for partition, right? So you can say this became the actual basis. This, no doubt, borrowed now many of the features of this act. So when this act comes, the implementation doesn't happen. When this act comes, actually 1990 Act is the act which influences the administration. But when this act comes, right, and when the constitution is created, or when we start making the constitution, this had dominant influence. And that is why we say that 1935 and the previous acts had deep impact on the formation of the new constitution of new India. It's not the Constitution of India, it's the new Constitution of New India, because whatever they had done earlier was a product, was a kind of effort towards making Constitution of colonial India. 1935 be a constitution hai of colonial India, right? So you can say that way that that was created, no doubt, under this Indian Independence Act or creation of Constituent Assembly 1946, right? The effort was not made to make this Constituent Assembly more inclusive in nature, right? There were elites, there were lawyers, there were dominance of caste or people who were higher in the cultural hierarchy. They dominated mostly this composition of Constituent Assembly. Fine. नोट्स में होगा पढ़ लेना कितने मेंबर्स थे, कौन क्या थे, कौन नहीं थे, ठीक है. You know, obviously, the around 22 committees were made of the Constituent Assembly, right? 10 related to procedural aspect, 12 related to substantive aspects. So ultimately, right, you can say that the effort to negotiate a constitution of independent India initiated after this act, right? Though 1935 act was fully visible in the new constitution. Why it happened? Obviously because of two reasons. One, that we wanted or we were accustomed to a political system, right? We did not want, we never, or we could not easily break away from that political history. Second, obviously, was that it provided us with a ready-made framework to govern, even though it was coming from a different culture, different mindset, right? It provided a ready-made administrative framework to govern. For example, All India Services, Union Public Service Commission, right? State civil services, subordinate civil services, provincial system of governing, right? Governor General's Executive Council, this council, that council. Already they were existing. Procedures were already created. So it provided us with a ready-made framework of governance, right? 1935 Act had lot of administrative procedures. Already, you know, Macaulay had contributed immensely to the development of the procedures, criminal procedures in India, right? Uh, then prior to that, if you see, there were certain scholars, certain administrators who had contributed to the development of civil services system, right? Especially, any name you know, Hastings created collector's office. Then Hastings' contribution to collector's office. What else? Munro, right? Dominantly civil services reforms, right? So Munro's contribution cannot be denied, right? Then, We'll talk about those facts, don't worry, right? So ultimately, the Constituent Assembly, in spite of going through numerous sessions, in spite of formation of 22 committees, right, in spite of looking at various constitutions of the world, it was dominantly influenced by this act. So we cannot say it was a copycat of this act, but it was dominantly inspired by this act because of certain reasons which we have said. It was easy, right? Ready-made framework was there. We were quite accustomed to these systems. Breaking away from the past is not that easy. Right. Fine. So obviously, 2 years, 11 months, 18 days. It took 2 years, 11 months, 18 days, 3 years, you can say, to form the constitution. Right? 26th November 1949, we established or we had concretized the constitution. 26th January 1950, right? We had already enforced many provisions by on 26th November 1949. But many of the organs of the state, many of unique provisions did not come into play or action unless we went for 26th January 1950. So, constitution made, right, adopted, enacted 26 November 1949, enforced from 26 January 1950. Not all the provisions, some of the provisions. So you can say some were already done and somewhere or rest were done on 26 January 1950. That means now the entire constitution enforced. Right. So why the date of 26 January chosen?
maybe 1928 में वो फ्लैग वहाँ पे
2930 लाहौर सेशन कौन सा सेशन we had accepted for Poon Swaraj, or we had talked about creating a independent constitution of India, right? Nehru declares Poon Swaraj, correct? 1930, 1930, correct. So that is why that date was chosen. Fine. So we had obviously initiated it. Obviously, we cannot say that by from 1946 to 1949 there was no government, right? There was a provisional government which was working. 47 to 49 we had a transitional government. Nehru was the prime minister. And you can say that way that the Constituent Assembly itself was functioning in both the ways, as legislature as well as Constituent Assembly. That is why when we say Article 368, right? So Article 368 does not give unfettered powers to the Parliament. The reason was that when the Constituent Assembly was making the law, right, making the provisions, the Parliament of that time was functioning. So when Constituent Assembly and that Parliament, transitional government is taken together, then Constituent Assembly becomes the creator and the Parliament becomes the creation. So for this Parliament, which was a consequence of that law, right, having the same authority, same identity is not possible. So that is why 368 puts restrictions on the union legislature that you are not Constituent Assembly. And if you want to act as Constituent Assembly, then you will have to go through a substantial procedure, substantial process. What is that process? You will have to act like the Constituent Assembly. That is why it is treated a distinct amendment, apart from when you see the amendment of the Part 1 or Schedule 1, right, or the formation of territories and states. That amendment is not this amendment. Okay, that is the reason. Because that is purely related to the sovereign power of the state. Fine. But 368 relates to the sovereignty of the Constituent Assembly that created this state. Right? But there are a lot of issues related to that. Obviously, That Constituent Assembly was not made by us, it was created by the Britishers, right? Does that Constituent Assembly enjoy that sovereignty which we enjoy today because we have declared ourselves sovereign after that and not before that, right? So there are a lot of technical issues, but not needed for you, at least in prelims. So we had established the Constitution now, enacted the Constitution. Obviously, when the Constitution was made, right, you know that certain facts, we had how many articles? And everybody is writing everywhere. How many articles were there? Three, 395 articles, right? 8 schedules originally, fine. Then we have 448 right now. Okay. So we have 395 articles, 8 schedules, right? And how many? 8 schedules, 395 articles, correct. How many parts we have today? We have talked about what is a part, what is a schedule, what is article, that we have talked about. 26 तो आज भी नहीं है. How many parts are there? 25 parts. How many parts were there when we started off? 18. 18 or 20? No, think about it. It's okay. Right. As of now, how many parts? 25 parts. Okay. 12 schedules. Right. 450 plus articles, but there's no title of 400. Right. The title is 395 only. No. You have no 396th article is not there. So you can say the number of articles are 450 plus whatever, right? But the nomenclature of article is not. Nomenclature remains the original. Fine. Okay. Fine. So obviously different parts or different provisions relate to different aspects of the state or Indian polity, right? Now, when you think of part one, schedule one, right? The article 1 to 4, right? What is this dealing with? State. Just now we said state. We discussed the definition, the concept of state, but this is defining the state in concrete terms and how it operates itself, how it identifies itself. See? So when you think of Article 1, you know India, that is Bharat. Shall be the union of states. Fine, you'll get a PDF. Kindly go through the important articles which are given there. You have to remember them. Fine, we don't want to remember on your behalf. We want you to remember them, right? So that you can recall it as and when needed. Right? That is Bharat shall be union of states, right? Keyword union. India, that is Bharat, right? Obviously, there have been various debates regarding this, right? We'll talk about current issues, many things. But let us be very clear about here. When we use the word India, we somewhere think of modernity. When we use word Bharat, we think of tradition. Continuity. Change. In the Constituent Assembly, people had mostly in favor of this, right? But Ambedkar and others, obviously, they realized that this would create a more negative perception of the country in the world, because it might relate more to the sentiments related to a particular community, right? Even though that is not the meaning here, right? Bharat Khand or Bharat world is not derived from a person, hmm? But it is related to, yes, the Bharat Khand, the entire territory, the piece of territory which was categorized as the Bharata, the Adi Bharat, right? But obviously, it had included a lot of cultures and diversities together. But as of now, when we say the meaning of Bharat, mostly relates to a particular type of source in history. Right? कहीं भी ऐसा कुछ even though mentioned है, right? History में word भारत आता है, but that exactly may not be the Bharat we are talking about, right? Modernity and change again represents more liberal values. Obviously, we were going to be a democracy. We had usurped ourselves as democracy, right? And as we were going for a democratic system, right, we believe that we will follow some liberal democratic system. So it is quite obvious that Britishers already had influence, and we wanted to break away from that influence. So the assertion of the term Bharat indicates that. But the term India also somewhere indicates that there is an international presence that we want to establish, not just our identity, but an international presence where India is also treated as one of the countries which have progressive value system. People give a reference to Indica by Megasthenes, fine, but obviously there is no technically evidence whether Indica, what it was written exactly in Indica, right? Bits and pieces are available of Indica, right? But yes, the Greeks used to call us that way, so we can accept that also, right? The word Sindhu, Sindhu to Hindu, and whatever. Fine. Let's say so. That is now. Obviously, politically, this statement becomes little typical because it was very clear that what exactly it wants to establish. Unlike, so Ambedkar was of the view that unlike the America, which was a kind of combination of states coming together, India is not a combination of the independent states or entities coming together. So he wanted to make it outrightly, establish it outrightly, because in US also it was not established on the original constitution. And that is why in the Philadelphia Convention they had to go for a specific law, right, under which the, or you can say the tendency of different states to move out of or to go out of this collaboration, right, was restricted. So even in US, because it was not mentioned earlier, right, they had to specify it that all the participating units which are there, they cannot secede from this association. So keeping that in mind, right, and seeing the Canadian type of model of federation, we are more inspired by the Canadian model, centralized uh, autonomy or centralization decentralization combination works in Canada, right? So seeing that, we went for that kind of idea. So we already wanted to specify that India is no or not a product of many states, independent states coming together. India is a single territory which establishes now its own internal structure through division, right? So that is why they use the word union. So union does not mean it has no federal characteristics, right? So can we say union is unitary? No. Union is not unitary, right? Union is not SR Bombay case, many cases, right? अभी recently जो तमिलनाडु गवर्नर का केस है, right? लॉटरी के लिए बेटिंग एंड गैम्बलिंग वाला जो लॉ था, right? So it's not unitary, right? It's It's neither unitary, it's not ideal federal, right? So people say कि भाई क्या है, तो पहला है कि भाई ये फेडरल है, asymmetric. That means it's federal but asymmetric federal. There are various provisions where you see that union has more powers. There are various provisions where we see they are coordinate, right? So Supreme Court itself has given the view that we are, or even Ambedkar was of the view that we are asymmetric, but state is not subordinate to the union, right? They both are coordinates.
It was more judgment.
No, no, Ambedkar itself said that we are not referring to the term union in that sense, that states do not have any autonomy, otherwise there would be no list, right? He said that we believe that it is amphibious in character, right? It is, chalo, we'll write it, don't worry. The Indian constitution is sui generis in nature, right? Sui generis means it is unique and evolving. Right? We can also say it has amphibious character. Amphibious character, time and circumstance, it can be this, it can be that, right? So it is not unitary, it is not ideal federal, it is asymmetric federal, it is what you can say coordinates rather than superior and subordinates, one of its own kind, right? Has diverse characteristics. It can be federal and unitary as per time and circumstances, right? Cooperative Federation, Granville Austin. Right? So obviously your first article establishes the name, fine, and technically the nature. Fine? Name भी है और nature भी है. Though you can derive from it, it is not directly stating anything, you have to derive from it, but it indicates that. So you have cooperative federation, right? From here, obviously we use or we start using the terms when we see the features of the constitution that Indian constitution is cooperative federalism, fine, it is coordinative federalism, right? It is cumulative federalism with unitary bias, federal with unitary bias, or unitary with federal elements. Some scholars have also believed that it is unitary with federal elements or subsidiary federal features. Dominantly unitary with subsidiary federal features, and they have given references for emergency, president's rule, and so many other things, Rajya Sabha status, and likewise. Right? Some have agreed that no, it is federal with unitary bias. So you can assume this way that okay, it has lot of implications of this statement, India, that is Bharat, shall be union of states. When you see the word shall, obviously it means that it will always remain and there is no tendency of its disintegration. In no circumstance it can be disintegrated. Obviously, why? Because the states do not enjoy sovereignty in the first place. The states did not exist when the union was created. The union precedes the formation of states, right? Because when you say that okay, India had acquired certain territories, those were princely states, right? But they were technically not states, they were not provinces. They were categorized under the 1935 act as a different territory, territory A, B, C. So उस definition में है ही नहीं कि वो state है, भाई वो तो territories थी. We have acquired the territories, right? So Article 1 and Article 2 gives us this power. We shall be union, right? And Article 2 says we can acquire territories which are already not part of the state. So you can acquire external territories, you can create a new state, right? You can create or acquire a territory and create that into a new state. And likewise, that means what? The external acquisition of external territories are not existing territories, but which are already a state. For example, princely state, right? For example, Arunachal, Mizoram, Goa, whatever. Yes, they were already technically a state. So if we acquire them, right, it is now our sovereign power to do so. So Article 1 establishes the name and the nature. Article 2 establishes that sovereignty over its own territory or acquired territory, right? So 2 is more related to what? The classification of the territory, right, in which there can be different types of territory. 2 and 3 have little difference. 2 defines our types of territory, and we'll talk about, don't worry. First, you see, so nature of Indian polity or Indian political system, its functioning, right, may move beyond these features, right? So we can say that yes, it is federal. Now, when you see SR Mumbai case, right, or 370 judgment, right, where the Supreme Court has said that internal sovereignty does not belong to Jammu and Kashmir, right? Neither external sovereignty, because the moment it has given or signed the instrument of accession, that very moment it has given us its sovereignty. That is correct. That okay, the sovereign functions of telecom, border roads, defense was to be performed by India. So obviously, that is also logical that in relation to the Jammu and Kashmir, we were already performing sovereign functions. So how can it ask for sovereignty from us when we were the one protecting its sovereignty? You can imagine this. If you are, if I'm protecting your sovereignty, then obviously I'm much more sovereign than you. So it becomes illogical, right? Territorial integrity is not visible in Indian constitution or is not specifically clear in Indian constitution regarding the states or the territories of the state. There is no territorial integrity available to the states or any internal territory, internal, right? We'll talk about it. See, so you have this typical character. So we can say that it is more of cooperative federal, right? It is federal with unitary features, right? And likewise. So you can get a question that, okay, out of all four, which of this uniquely defines the Indian polity or nature of Indian political structure, right? Sometimes it may seem that all of them are correct. So put, if the option is there, federal with unitary bias, क्योंकि ये सब क्या है? ये सब opinions हैं, facts नहीं हैं. क्वाजी फेडरल ओपिनियन, कोऑपरेटिव फेडरेशन ओपिनियन, राइट? सुप्रीम कोर्ट कहता है फेडरल है तो फेडरल है, एज सिंपल एज दैट. फेडरल ऑफ इट्स ओन टाइप. So we should neither say quasi-federal, right? Nor we say federal with unitary bias. Let us say it is federal of its own kind as per the Supreme Court.
Sir, just wanted to, in the previous class we talked about sovereignty of the states. So all the states which are in India, they don't have external
They
sovereignty.
don't have. They don't even have internal sovereignty.
But even while into Jammu Kashmir, the other would have internal sovereignty.
How can there be internal sovereignty?
For example, for states like northeastern states,
No.
they,
When the principle will be applied, it will be applied to all. Right? How can we apply specific principles to specific? Right? For example, right? See, when you say that there are certain states which have special status, fifth schedule, sixth schedule, 371, 370, they have special status, right? Who recognizes this special status? The union government, right? What is the basis of that special status? Is it territorial integrity? No, right? Development needs, regional problems, right? Some other cultural issues, cultural distinctiveness. So, what is the basis of how it is legitimate to have its own constitution? Who said? 370 is a wider political discussion, right? We have to understand it that way. So, whenever you are saying that special states, right, the special status is not given, right, on the basis or the format of association. It is given on the basis of their specific needs. So, politically, whenever special status is given to any territory, it is not treated distinct from us. It is only treated distinct for specific purpose. The entire territory per se is not treated distinct. पहले ये समझ लो. तो पॉलिटिकली उसका कोई स्टेटस नहीं है, राइट? सोशली है, इकोनॉमिकली है, कल्चरली है. दैट इज द रीजन. फाइन. जम्मू एंड कश्मीर, लाइक वी सेड, कॉन्स्टिट्यूशन, but it was obviously established by that arrangement, right? That it can have its own constitution for transitional purpose. It was not a permanent constitution. First, understand that. It was done for transitional purposes so that the trust factor can be established. And certain provisions were integrated in that constitution just to make sure that this territory was, first of all, quite vulnerable. Secondly, it was very distinct from rest of the country. Thirdly, it was very close to the proximity of hostile neighbor. So it was agreed upon by Nehru and others, obviously, that the typical or you having a kind of special document or your constitution should be guaranteed only for the transitional purpose, not for absolute control, absolute functioning. That constitution was not permanent constitution, right? So many of the laws which were to be enacted by parliament would be enacted by them, would be approved by their assembly. Most of the times it was approved. They had no option to say no. Right? We were already providing, controlling the defense and so many other fact things. Right? Secondly, because we said there is dominant population of a particular community, and that is why they should be given some freedom, right? So that to protect and preserve the sanctity of that contract which was made by that, right? But you see, the moment you sign a contract or access or what you can say document of accession, that very moment Article 3, Article 2 comes into picture, right? You become the part of Article 1. भाई अगर जम्मू कश्मीर स्टेट भी नहीं है, यूनियन टेरिटरी भी नहीं है, तो क्या है? तो बहुत बड़ा क्वेश्चन मार्क है ना भाई. हमारे यहाँ तो यही टेरिटरीज है ना. Well, this is how we have defined in the constitution, right? Your union territory or your state territory, right? Or any other territory acquired by the union or the government or state over a period of time. So what kind of territory you are? Are you annexed territory? We did not annex you. You came to us, right? In that ground, on that ground also we have the sovereign power over you. Right? You are already a state, yes. Maybe you are existing as a state. We took you under our fold, right? Then automatically Article 3 again comes into picture. Or 2 and 3 both come into picture. Right? So the moment you agreed to join us, right, you are aware of all the conditions which are there. So idea was कि भाई see, Can you go back to your own sovereignty in future? That was not clear, never written. Right? So that is one dilemma. So how it can have? It can have its legitimate constitution, but purely which which follows the principles of association between them and us. So when we say it is integral part of India, yes, it is because there was nothing else existing then, right? So either they had option to go to Pakistan or India. भाई दो ही डोमिनियंस थे या दो ही स्टेट्स थे टेक्निकली उस समय, तो आपको कहाँ जाना था, राइट? You would not have been recognized even as a territory if you are not part of India. Right? The Britishers would have claimed you as your captive territory, right? They would have said, okay, fine, neither you nor us, we will claim this territory as our own territory. Like Ireland, Wales, and many other places they have done, right? Japan, Australia, New Zealand. So logically, the features or structure of the polity, right, depends to a large extent on the essence of what is written in the Constitution. So Constitution, when you look at list 7 or 7 schedule, 3 lists, right? And then you realize that, okay, fine, when we read all this, Article 1 to 4, 7 schedule, 3 lists, and certain other features or functions which are there, emergency, 356, 352, 365, when you read all this, right? Then you realize that, okay, fine, it is neither completely unitary nor completely federal. It is a combination of both, right? So you can say it is more amphibious or evolving in nature. Fine. Okay. So what are the, let's say, the features now? Or let us say. So Article 1, right? Article 2. What does Article 2 talk about? The territories. Technically, what territories are there? Classification. So what kind of territory we have? We have state and its territory, union and its territories, right? And any other territory that we may acquire over a period of time. Okay, right, right. Now see, union territories, when you say the state and territories, or union territories you can say, and specified in first schedule. Whenever state is created or renamed, whatever, the first schedule changes. What does the third term union territory or union and its territory mean? Right? Or you can write, chalo, such territories when you say union territory or union and its territory, it relates to union government and states. Right? States. But technically word union जो article 1 में है वो क्या है? India, that is Bharat, shall be union of states. What are those states? Those states are the states, provincial states that you have defined under Schedule 1. फर्स्ट शेड्यूल में उन सारे स्टेट्स का नाम है ना भाई, जो स्टेट गवर्नमेंट्स या जो भी स्टेट्स डिफाइन होते हैं. So when you use the word union, that means it comprises of all the territories which are demarcated as states. Understanding? So when I say union and its territory or union territories, it's not technically that union territory, right? Try to understand. It is the union government, which automatically includes those union territories which are governed by the union government and the states which are there. So when you say union, The word union specifies that all the states, the regional units, they are part of this definition, right? तो अगर मैंने बोला कि भाई टेरिटरी ऑफ इंडिया क्या है, तो वो तो बहुत बड़ी है. बट यूनियन ऑफ इंडिया क्या है? स्टेट्स और यूनियन गवर्नमेंट, ऑल द स्टेट्स which form that union government. So here the term union in the Article 1, right? It is very specific that India, that is Bharat, shall be union of states. What? Union of what? The states. Because any other territory which is created, that automatically belongs to union government. So states तो उसका हिस्सा होंगे ही होंगे. States will be mandatory part of this association. So this term union automatically includes all the states. They cannot go out of this union. Try to understand. Any other form, already it is part of union government. So when you say कि भाई union of India reflects what? The union governments and union government, the system, and the states. Right? When you say territory of India, the territory of India is a bigger term which includes that union, right? Plus the other territories which exist. What other territories, right? Which may acquire, which exist beyond being part of the state. See, something is not defined as the state. That will become part of territory of India, right? Those all those territories which are defined as states, they will become part of Union of India. Are you able to understand this? So when I'm using the word union, it has very specific meaning. When I'm using the word territory of India, it has a specific meaning. For example, let's say India acquires or India has a sovereign control over a part of Iceland, right? Or Greenland. Now there's a lot of conflict going on in Iceland, right? So let's say India has part of one particular area, right? Which sovereignty or the sovereignty of that belongs to India. Right? India exchanged some enclaves with Bangladesh, right? So whatever earlier territory was there, no more is there, right? So if India acquires now that place in Iceland, for example, is not a state. It's not under the definition of a state government. May in a way. But is it not part of India? It is. So we'll not say it is not part of union, right? It is part of territory of India. So territory of India includes the states, the union territories, any other territory that belongs to us or may be acquired over a period of time, right? And the other type of international law defined territories which come under us, right? For example, the 200 nautical miles of oceanic resource that comes under us.
Directly we're talking about the Navy and
Wherever our sovereign authority extends, air, navy, anything. Right. See, understanding this logic. So wherever our now sovereign role extends. So when you think of the maritime boundary, right? So we have control over marine resources to the extent of 200 nautical miles, which obviously we are fighting to extend. Every state is fighting today to extend because we are dominantly a littoral state. We have a lot of water around us, right? So 200 nautical miles or 12 nautical miles from the continental shelf. Okay, whatever that boundary or that you can say slope or that boundary extends to the sea surface or seabed, that also belongs to us. Why it is needed? It is needed to create ports. It is needed to create ensure security. It is needed to create a maritime boundary and a lot of other things. When we think of the 200 nautical miles uh, marine resource, control over marine resource, right? Then we have resource or control over the resource which are below the surface water. The surface water belongs to the international law. नहीं समझ में आया? सो लेटेस्ट से हाँ अरे यार देखो ठीक है अब यहाँ से हमने एक्सटेंड किया बाउंड्री राइट 12 नॉटिकल माइल्स राइट ये चलेगा अब यहाँ से स्टार्ट हुए पानी अब ये हमारा बाउंड्री यहाँ तक जाता है पानी यहाँ पूरा आ रहा है फॉर एग्जाम्पल नाउ वाटर इज फ्लोटिंग अबव राइट बट जो रिसोर्सेज है वो कहाँ है सीबेड पे भी कुछ भी ऑयल हो, नेचुरल गैस हो, कुछ भी हो, वॉट एवर, सी बेड पे जा रहे हैं ना भाई. वी नीड एक्सेस टू दिस और वी नीड एक्सेस टू दिस part belongs to international law or United Nations or neutral. This part, water, only the surface. Below the surface belongs to us. That is the idea. So 200 nautical miles, the surface or the seabed or the resource belongs to us. But sorry, not the surface. Below the surface belongs to us. Right. Otherwise, it can be 12 nautical miles. That is the established boundary. Fine. And likewise. So we have, or any other territory that we acquire over a period of time. Now see, so Article 12 talks about that. कैसे हो जाएगा ये बताओ. बोट्स चल रही हमारी नहीं है. We cannot use the boat, but we have control. We have claim over the resources. If gold is found within it, it will be ours. Right? But if we have to travel, it's not ours. Right? We'll have to seek permission or we have to accept that these are international waters. Right? Can you control a natural resource like that, water? मुश्किल है ना भाई. And water is connected to another water, water is connected to another, so that will be a big problem. But where can we claim control over physical resource? Yes. Mineral resource? Yes. Fishing? बिल्कुल resource control हमारा है. Right? Because see, this establishes the principle of equality amongst the states, right? So some have a lot of resources within them because of their terrain. Some have resources because their terrain is located near the oceans and rivers, right? So it balances the resources. So you cannot control the water, right? You can control. So anybody who enters that water but founds a resource, it belongs to you, or at least royalty would go to you. Correct. Fine. Okay. So let us say you classify. You classify the territory in order to understand कि भाई where the nature of relationship is federal, union state, union or territory जो है, right? And where the nature of relationship is not federal, technically there is sovereign control of the union government. So sovereignty in that sense, from this definition also, the sovereignty lies with the union government and not with the state. इस definition पे भी see, imagine if a state has a boundary or a state has a oceanic boundary or a sea boundary. Let's say Goa हो गया, Tamil Nadu हो गया, for example. Now who will control the resource? Will the state or the union government? Union government. The sovereignty will lie to that, right? They will, yes, they may make mechanism of giving royalties to the state to which those resources are adjacent. So that is logical, see? Because see, internal arrangement depends on the union government, union legislature, right? That is why the state cannot absolutely claim by tomorrow you are not a state. Or tomorrow you are not that state which were claiming our control over this. You have been divided now. Are you getting? So that control, sovereign control over the resources remain with the union government. Right. So you define the state and territories. Union territories, such territories which you may be acquired. Obviously, when you are defining these territories, you have to, demarcate. While the time a territory is declared as a state, it enjoys all the rights and autonomy of a state government. Right? It is treated as part of the federal system. Right. But does its territorial integrity, is its territorial integrity permanent? When you say India, that is Bharat shall be union of states, right? Is it defining somewhere what is a state? No. But it is mandatorily saying that, okay, there will be union of states. So union permanent hai, union prominent hai compared to the states. So states will exist and they will have autonomy, right? They will be treated coordinate with the union, fine. But will they have now territorial integrity. Will they have internal sovereignty that you are asking about? They will not have now. If they had internal sovereignty, they would be resisting any action or any control by the union. So you write one or few things, okay? Right. Article 1 defines India as union of states, states, and the states and the territories are specified. States and the territories are specified in the first schedule. Unlike American colonies or Swiss cantons, Switzerland, or Swiss cantons, or Swiss cantons, these territories were not sovereign or independent. Right? That means Switzerland and America were formed by independent territories which were already independent before they became part of USA or Switzerland.
They have the internal sovereignty.
Now they don't have, no, because now they have established. They have sovereignty internal, yes, but they don't have external sovereignty. Right. The territory of India that is defined consists of three categories. That is state territories, union territories, and territories which may be acquired by government. Acquired by union government. The term acquired, this is important. The term acquired is defined as per the international public law, the laws which govern the states. International public law. And there is no need for parliamentary law or parliamentary legislation. There is no need for parliamentary legislation. as as it is the right of a sovereign state to enter into agreements or provide declarations for the same without violating any international law. So if it is under international law, that is the annexation or acquisition is not by violence, by force, by any other thing which is violated by the international law. If you are doing it, it is your free will, it is your sovereignty, and you do not need to get permission from anyone. Right? And for that, obviously, you don't need any parliamentary legislation because it is purely executive act. But if you have to give territory, then you cannot do so. When you're acquiring it, you don't need that that legislation or that approval. But when you are giving the territory to any foreign country, okay, that requires an amendment, that requires an approval, provided it is not a border dispute, right? So it is not a solution to any ongoing border dispute. If it is a solution to any ongoing border dispute, right, then it's said that you do not need approval, you can go for executive decision, where already, let's say, a law is made on that. So if already a law is made, then you don't need to go for it again and again for any parliamentary approval or enactment or amendment of the constitution, but only when it is to settle the boundary with an adjoining neighbor. जैसे 100th Amendment एक्ट हुआ था, इंडिया बांग्लादेश का बाउंड्री डिस्प्यूट सेटलमेंट 2014-15, we went for that, right? For that there was no need for a separate constitutional amendment, right? Because it was not ceding the territory, it was exchange of territory. That is called executive action, right? But in case, obviously, you are acquiring a territory through legitimate means, you are undergoing through a kind of contract between with a state with any territory, right? Or by a declaration, you have publicly notified that okay, this territory is going to join with us, or likewise. ठीक है, गोवा सिक्किम ये सब ऐसे ही हुए, ठीक है. So technically, for that there is no separate law required, right? Now see, so obviously any territory, once acquired now, it is up to the union government, it is up to the center or parliament how they are going to treat this territory. They'll take it as a state, make it as a state, keep it as union territory, do whatever. See, that's why we say the internal sovereignty does not. Once you become part of it, right, you cannot claim that, right? Understand? So when Jammu and Kashmir claims the benefits from union government, when it claimed all the resources of the union government, when it claimed all the protection from the union government, then how can it claim that I should be treated separately from the other states? Right? On that ground also, you're distinctive because there is a time frame for that distinctive status. It's not a permanent. Special means what? Something which is not permanent. भाई स्पेशल स्टेटस तो दिया जाता है किसी पर्टिकुलर टाइम सर्कमस्टांस के लिए ना भाई, तभी तो उसको स्पेशल बोला गया. फाइन, बच ओके, ठीक है, राइट. नेक्स्ट लिखो एक लाइन और. दो लिखे, though a territory cannot be ceded, territory cannot be ceded, without a constitutional amendment, unless it is a settlement of, unless it is settlement of a prior boundary dispute, prior boundary dispute. Dispute. In the bracket we write, same happened with Bangladesh. Exchange of enclaves with Bangladesh. So it also seems quite illogical that if Rahul Gandhi claims that Indian government has ceded a large part of territory of Arunachal to China, this seems highly unlikely because for that they will have to go for a procedure. We have a boundary dispute, right? But our boundary dispute with China is not of consultative nature. Right? We have already alleged that it has encroached upon the territory. We are not saying we have any boundary dispute. We are only saying that you have invaded, you have acquired, right, with or without following the decorum of the international law. So there is no chance, there is probably no logic of having a consultation with China. You have invaded, you have annexed, and forcefully or through what you can say the underhand means you have done it. So obviously there does not arise any chance of having consultation with you. LAC internationally, which is projected, may not be actually on the ground, right? Same is with the LOC. We are technically having a ceasefire on that LOC, right? We are not encroaching into Pakistan anymore. They should not encroach into India anymore, right? But this ceasefire is conditional. So see, there is still to recognize the international, or there is no need for, sorry, to have an international recognition regarding what our boundary dispute is. We don't want that. नहीं चाहिए ना भाई हमें भाई इंटरनेशनल आर्बिटर नहीं चाहिए ना हमें उसके लिए राइट बिकॉज सर्टन थिंग्स वर डन फोर्सफुली certain things were done illegally, certain things were done in the spirit of fraternity and community, certain things happened, right? So if we have to settle it, it has to be settled through bilateral means only. Bilateral ही होगा, right? Because ये purely एक personal conflict है. Right? There was no international recognition, there was no fixed, ठीक है उसने जो line बनाई whatever, fine. But how it was totally clear, how it was totally defined, but it was not totally defined, right? Because unless it was done when we were sovereign, we would not accept it. It was done under someone's control. How to accept it? Fine. क्योंकि ultimately जो भी British record रहा होगा उसके पहले, whatever British records were there before that, they would all be keeping all the entire Pakistan into India. That was the entire India, no? So the moment you say British India, what was that British India? That was entire India. Right? Bangladesh, Pakistan, everything, including that. So all your records will refer to India as that. Right? So after the partition, what you decide may not be taken as the sovereign decision made by us. Are you able to understand? Now see, Article 2 obviously talks about what? Now Article 2 talks about the admission of new states. Okay. 2 and 3, this is to be distinguished. 3 talks about rearrangement of the existing. 2 talks about admission of new states or creation of new states, but not from the existing. Right? Once you define the territory, right? Now what will you do? Obviously, you're trying to now define that how this territory can be treated, how it can be changed, how it can be modified. तो हम उसको define करते हैं, sorry, process explain करते हैं. Now see, so when you say Article 2 exclusively focuses on what? The admission right? Or creation, not formation. Something which is being done for the first time, right? Creation of new states. Now this Article 2 obviously, okay, you can write a few lines, okay? Right. The Parliament may, by law, admit into union or establish new states on such terms and conditions, as it thinks to be fit. Right? So main powers belong to the Parliament under Article 2 to admit new state, to create new state. This you must remember. Article 2, the main power belongs to the Union, Parliament, one to admit, one to create new states. These new states are not the existing states, right? When we are saying existing, at that point of time we are talking about, right? Existing. तो existing is जो situation है उस समय, right? So now it can do it, right? Right. It is that typical that Article 2 gives a complete discretion to Parliament to Parliament Parliament and it does not allow or provide any guarantee. It does not allow or provide any guarantee to this new state to be treated equally with the other states or with the other existing states. Right? Now see the logic that whenever we are admitting something, right, the parliament by law, right, that means it can make a law, it can amend the constitution and include, right? Many territories were done that way, right? So parliament can do it. It is a complete decision of the parliament that it can admit, it can acquire it, it can provide terms and conditions for its association with the rest of the union, but it does not give. The moment you become a state or you become territory, not the state, let's say, right? You you somewhere acquire the right to be treated at par with others because you become the territory. But here, under Article 2, this is a unique discretion given to Parliament that Parliament will decide what would be the status of this territory. And this territory will not demand now, like the other states, having the similar status as they are being given. Right? On this ground, also, Jammu and Kashmir can be controlled more. You cannot ask for the status, even though chalo, we signed an agreement. Right? Otherwise, what is your political entity? What is your political identity globally? Nothing. Right? So, 2 provides this uniqueness that you can admit, right, acquire, new, right, but may not necessarily give it the same status as the others. So, the bargaining power of the states under Article 2. Now, the question can be like this: the bargaining power of the states or the territories under or acquired under Article 2 is not similar to the bargaining power of the states which already exist under Article 3. Right? Article 3 talks about internal rearrangement, right? Article 2 is more focused on external or acquisition of external territory for creating or for developing or making the union territory or union government, for establishing the control of union government. So acquiring externally, rearranging internally, two different things, right? Now, obviously, the internal states lack that sovereignty, and those which have been acquired also lack that sovereignty. So, ये तो clear cut है कि whether you are in Article 2 or Article 3, in any case, your sovereignty is not going to be protected. Fine.
Even if the Article 2 or 3 no state can demand that so की power में भी ऐसे treat करो.
नहीं, but 3 में तो demand कर सकते हैं because they are already recognized as states. UTs with legislative, right? But whatever Kejriwal is making the demand, it is illogical. Fine. UT has been given, that is also the union government's power, union parliament's power. So 239 AA was made just for that reason. It is up to the union parliament. It is up to the union government. Right? So even if you are creating the legislative assemblies in the union territories, that is done for administrative convenience. Right? That is what done for political recognition, a territory to give its identity. That is why it is done. It is believed that there is huge population and this population should not go unrepresented. Okay, that is the idea. तो यूनियन टेरिटरी तो यूनियन की ही टेरिटरी है, उसमें तो जो चाहे कर सकता भाई. इट हैज टू बी एडमिनिस्टर्ड बाय द लॉज गवर्न, राइट. Sikkim can be, yes, as it was acquired, correct. Sikkim was done through it, but through constitutional amendment, you can say, right? So whenever, now it is up to the parliament technically, right? So whatever it does under this articles, it is not to be treated as separate amendment, right? Or constitutional amendment, it is amendment, but it is not constitutional amendment article 368. Obviously, it will modify schedule 1, right? It will change the names, the territories, whatever, but it will not be treated as separate constitutional amendment. So it will be treated as ordinary legislation, just like any normal legislation. Right? Because yes, Sikkim, like you said, 36th Amendment 1975. That's correct. Right? So, 2 now. Article 3 obviously focuses on what? The rearrangement of the states. What can you rearrange? From 2 states, you take some territory, make a new state. You can do that. Already existing state, you take out some territory, give it to other existing state, right? And redefine the boundary, that you can do. Rename the state, that also you can do, right? Take a part of the union territory and the state and integrate them together and create a new state, that also you can do, right? You can do that. Creation of state. Now see, try to understand. This article uses the term creation of state, rearrangement of state. But it somewhere not clearly establishes that whether this term state here, which is used, also includes union territory. ये clear नहीं है. Now see, union territory is a different type of territory. State is a different type of territory. So when we read Article 3, it becomes little confusing that whether the word state here includes union territory or not. And this was the doubt raised under Article 370 in the Supreme Court, that whether a state can be converted into a union territory or not. Where this technically complicates things, no? Ki bhai, there is a state, it has a status. It comes under list 2, right? Schedule 7, it has certain powers. Now, can you convert that state into union territory? Carving out a union territory from the state is okay, right? But degrading, when you see the status of a state, when it is made a union territory, its status degrades. That was the doubt raised. And that is why Supreme Court said you must conduct elections as early as possible in Jammu and Kashmir. Restore the legislative assembly. That means in Article 3, this is very typical that, okay, you can rename a state, you take a part of the state and part of another state and create a state, right? You can take, you can change the boundaries of a state, you can alter the territory of a state, you can change the name of the state, you can merge 2 states to create a state, right? And likewise, but can you make a state union territory? That is not clear. The word state used in Article 3 does not necessarily constitute union territory, because that will be a simple rearrangement of the territory by the union government. उसमें state तो involve ही नहीं हुआ. Fine. So can, this is the question, right? That was also the question raised in 370. Can a state be treated as union territory by the union? No, it cannot. Right? It violates the entire federal principle. Inferior treatment to a territory from the state to union territory. When you convert a state to union territory, you directly hand over the power, you undermine the representation, people's representation, and you hand over the power directly to the union government. It is a method of centralization, right? So India, that is Bharat, shall be union of states. Union which can come with its own territory, but it has to be part of states. So who has been given prominence in this arrangement? States, not union territory. So the tendency of making union territories, that is not, or that may violate the spirit of constitution, right? Converting states into union territories violates the spirit of constitution, right? But unlike article 2, now here let's say we said कि भाई हम उसे we cannot degrade the status. The word state does not actually mean also includes union territory, no, right? Otherwise it will become inferior, their status will be same, otherwise it will be illogical. Why to use the word state? हर जगह union territory use करो, it will be illogical, right? Also, in Article 2, right, uh, there is no need for consideration of the states. When you're doing or making changes to the Article 3, major changes like name, alteration of boundary, right, there you require, right, the consultation of the states. But that is only a formality. Because the law or the proposal to restructure the states, change their names and boundaries, realign internally, right, it is a bill which is presented or which has a prior recommendation of the president, right? So before actually that bill is presented, or once the bill or provision is created, formality's sake it is sent to the states for consultation, to those states which are affected, and there is a time frame set by the president. If they don't give their approval in that time frame, it is considered to be their approval of not giving any approval, right? Even if they give the approval, the president or the union government does not have any foundation to accept whatever they have said. If they give any advice, any recommendation, it may or may not be accepted by the union government, and they'll go ahead, generally they go ahead with that. So in that scenario, Article 2 again varies from Article 3. There is no need for approval of that state or any state, right? Here, they need, sorry, approval, I'm saying, consultation or inputs or some advice, right? And something like that. So this process of formation, restructuring, renaming, right? Realigning the boundaries of the state itself indicates that states do not enjoy territorial integrity, but see, states enjoy political integrity. Once they are a state, right, they have political integrity, they can make policies, they can make laws, they have separate functions, they have a separate political office, chief minister, right, and likewise. So they have political integrity but not territorial integrity, right? It is also doubtful that they may have socio-cultural integrity. Why? Because the moment name is changed, the moment boundaries are rearranged, the socio-cultural composition of the state changes. Uttarakhand being part of UP, right? Today no more, it is part of UP. So one aspect of the cultural identity of UP has been exhausted, eliminated. Right? So ये भी एक यूनिक थिंग है कि भाई see, consultation is done symbolically. It is a procedure which should be followed, but it has technically no meaning as far as the restructuring of the states is concerned. The term state need not necessarily refer to the union territory also. The term state gives a better identity, a higher identity to a territory than compared to the union territory, and likewise. So even the tendency of the union governments to have legislative assembly in the union territories, to have chief ministers in the union territory, is somewhere undermining the importance of these states. Right? Whatever they talk about, but in reality, it is another way of undermining the importance, the status of the states in the overall governance. Right? So 3 relates to that. 4 is what? Hmm? Correct. Basically, Schedule 1 और Schedule 4 ये changes में आते हैं, right? Generally, Schedule 1 relates to territory, the name, and all those things. Schedule 4 relates to the seats in the Rajya Sabha. So, obviously, whenever the internal rearrangement will take place, new states will be formed. Their representation has to be made, or an entire old state is to be recreated. There will be some change in the representation in Rajya Sabha, even though it does not make things any different. Because Rajya Sabha's role in the federal relation is quite limited. Its representation is inequitable, right? Unequal representation is there. Also, the states which have less representatives, they are more distinct, they are more unique, they have more problems, they should be represented more. Fine? Rather than politically active states who already have a lot of membership in the Lok Sabha, right? Or they are more vocal and politically active at the national and regional level. So those states obviously don't find the voice. They are subject to political neglect. So that is also one logic that okay, even if you're restructuring, re-altering the seats in the Rajya Sabha, are you actually providing that kind of voice which is needed? But it has to be done. It is also a procedure. So we try to creep that federal element. Even when we have an express provision, we have a unique constitutional, uh, what you can say, um, transparency regarding that states do not enjoy any territorial, right, integrity. So we say, like in US, obviously any kind of rearrangement is not possible. Any alteration in their power is also not possible, right? Except for obviously sovereign reason, expressed for except for security, right, and so many other factors. Otherwise, the states are completely internally sovereign. Their decisions cannot be in any way impacted by the union government or federal government, right? They have their own supreme courts, right? So unless the matter relates to the federal government or relates to the center-state relations or relates to the union government, right, it doesn't go to the federal court. Most of the problems are resolved by the independent states themselves. Policy is their exclusive domain. No central government can encroach into the policy. Policy is considered to be their sovereign function. Lawmaking, sovereign, right? And likewise. So you can imagine this way that there, these states enjoy that kind of autonomy, right? In Indian context, also, when they are acting as a state, then they enjoy that autonomy, right? They can make laws, they can have this, they have separate identity in the list, right? In the constitution, they are mentioned separately, their political offices are mentioned separately, the chief minister is considered to be equivalent to the prime minister at the national level, right? And likewise. So बहुत सारे ऐसे provisions हैं which also indicate that the identity of the states is not totally diluted, but still, right? America is considered to be the indestructible union of indestructible states. Why? Because the states enjoy territorial identity, territorial integrity, territorial sovereignty, right? On the other hand, in India, it's called the indestructible union of destructible states. The simple logic is that states can be restructured, rearranged, renamed, and their boundaries can be modified by the union, right? So now, if we understand this four or these provisions, right? Do we agree that okay, yes, India is now not a federal system? So if you see, if you get a question that looking at the provisions of Article 2 and 3, or looking at the definition of Article 1, right, does it indicate that India has more unitary tendency than federal tendency?
In Article 1, within states, union states, the states have their unity. They have that status. Maybe it can differ. But it is not partial, just talking about.
Right, okay. ये क्या है वन इसको यहाँ लिख दो ये आर्टिकल 2 दिस इज 1 1 2 3 One ka 1, 2, 3. Okay, let us see this one. Shall be, right? Shall be, permanence, obligatory, must. Shall be union. इंडिया क्या होगा? यूनियन. ये तो पहले प्राइमरी है. दिस इज मस्ट कि इंडिया इज यूनियन, राइट? देन कम द states. So even in Article 1, the status of the states is quite secondary. Understand? Not primary. The union is treated primary compared to the states. But you can say definitely that we were not borrowing the model of the British, the federal model, and we were somewhere trying to, uh, yeah, we were trying to have our own combination of unitary and federal features. Whether we borrowed from Canada and not from US, right? Whether our parliamentary democracy was influenced by UK but not totally the model of UK. So somewhere we made modifications to the existing. तो हम ये बोल सकते हैं कि yes, these provisions somewhere indicate more unitary bias with federal features. Right? You cannot simply say that a statement one indicates federalism. No, it does not indicate federalism. Right? Right. Fine. So once, now see, you have defined the territory, you have various provisions. If you go by the international law, we have defined the territory. Now we have to define the population. Several issues have been raised, let's say, before and recently also, right? Regarding the concept of Akhand Bharat. Is it constitutionally provided for? Yes. Article 2, you can acquire territories. That is your sovereign right. Nobody can stop you unless you follow the international law or be consistent with the principles of international law. But that will also be illogical because many of the states which form the part of the Akhand Bharat are now sovereign states. But they have their own sovereignty, right? So unless they are willing to give us their territory, right, or unless we are acquiring it through consultation or a resolution or a contract, it will not be considered to be logical, right? But yes, you can say that yes, in future we never know. There have been agreements like that, right? States have come together, right? अब technically अमेरिका को ही देखा जाए तो अमेरिकाज देखा जाए, North America, South America, right? The middle part, the transition. So everywhere you see, they always wanted to do these things. Every country, even in today's context, is trying to have that presence politically and territorially, both. Right? But it may create problems in the future. Because excess diversity will also be a problem. Fine. Then, fine, it's okay. But we can maintain our secular identity and we can still have something called Akhand Bharat. Right? Our secular identity nowhere is undermined, right? By the acquisition of territory, renaming of states, or whatever. Kyun? Because our basis of creation of state was mainly the linguistic basis, even though it was not accepted by any of the committees, but it was linguistic. Why? Because language, and we have kept language as the binding factor, not the religion. Because language integrates community. Religion disintegrates community. That is why language as the basis is more a binding force than religion. Language develops common culture, common understanding, right? And likewise, so you can say that in reality, if we do all these processes, if we restructure things, if we rename things, right, it doesn't violate technically the principles of secularism, right? It doesn't violate the principles of integrity. It doesn't violate the principle of fraternity and brotherhood and nothing like that. Right? It is more of a political rearrangement, or you can say it is more of a boundary rearrangement. Right? That is also something good, that states do not have territorial integrity, states do not have internal sovereignty. Otherwise, what will happen? It will become difficult for a minority to live in a state which is dominated by a majority. That would also have been difficult, no? Anyways, the state knows that there is central government's influence, right, overarching power to control us, and that is why it is not able to do many things it may want. Whether you talk about northeastern states or you talk about racism in Karnataka, Delhi, right, or in Tamil Nadu, or you talk about the north-south divide, which is mostly visible in the southern states, even in northern states. If that was the case, right, many states would have made their own laws, they would have segregated the boundaries, they would have restricted the movement of people, and they would have done a lot of things. Right? For example, in Arunachal or the northeastern, the inner line permit. Have you heard of it? And we'll talk about that issues. Don't worry. Inner line permits are issued. Right? Abhi, you have seen the the extreme conflict in Manipur, the ongoing conflict between various ethnic communities in the northeast. Right? The different movements, चाहे दार्जिलिंग गोरखा हिल या दार्जिलिंग गोरखा रिवोल्ट्स हो, प्रोटेस्ट हो, राइट, और एजीपी असम गण परिषद इन असम, और आईएम, it's like visa within India, correct, right? Or we have this NSCN, right, Kuki movement, right, Mizo movement, and there are so many Naga front, and so many typical factions exist, collectively called as insurgency, right? Factions exist, mostly politically influenced and territorially influenced. So there is so much of diversity within that area that if they had enjoyed sovereignty, there would be perpetual wars and conflicts in that area. So sovereignty नहीं होने का भी फायदा है ना भाई states के, right? So logically you can understand that both has pros and cons. Some recent developments are there. We'll talk about it when we take current perspective, right? Current issues, policies, and governance. So, right, बाकी changes क्या हुआ, 370 क्यों है, क्या है, तो कुछ चीजें, but it is not much important for the PT. For PT 370, 371 में comparison हो सकता है, right? And likewise, instrument of accession क्या होता है, right? What are the basic guidelines, international law on such contracts? This can be the question, but not more than that, right? So 1 to 4 becomes quite an important area. Once you define now the territory, you have to define people. So Article Part 2, Article 5 to 12 or 11, not 12, deals with the definition of people or the citizenship as we use the word. Right? The term citizenship has unique meaning in the political vocabulary. Right? With respect to constitution and politics, it has a unique meaning. Right? Citizenship is an attribute of a political system, right? Or it comes with the idea of state. So when we think of democratic states, we think of citizens, right? When we think of obviously any other form of state, we may not directly think of citizens. So the concept of citizenship is basically an attribute of liberal modern democracies. Those states which value the individual freedom and liberty. Okay, same way like we said from monarchy, subjects we have shifted to citizens. Citizenship gives enormous powers to the citizens. It gives what you can say more comprehensive identity, which includes both legal and non-legal aspects. Right? For example, you are citizens with respect to the fundamental rights, with respect to the rights of the state or powers of the state. Sovereignty belongs to you, and so many other things, right? But your Your nature, your identity as a citizen is not just what is established only legally. There are a lot of conventional aspects which establish your identity. कन्वेंशंस भी हैं, हिस्टोरिकल फैक्टर्स भी हैं, कल्चर भी है, बहुत सारी चीजें स्टैब्लिश करती हैं. फॉर एग्जाम्पल, सिटीजन्स कैन enjoy their freedom and liberty, but at the same time, they have a freedom to express their culture and their views. You enjoy your freedom, do whatever you want, but when you are expressing, when you are exhibiting your culture, your festival, your tradition, what are you doing? You are not only performing it in your free place, in your space, you're also using the public space. Right? You go on the road, you start doing something, try to understand, right? Or you're making a noise, you're shouting, you're singing a song. What are you doing? You're disturbing the common space. So concept of citizenship exists with the concept of community. Citizenship may be more about individual, right? Identity, political, legal, but community is more cultural, social identity. Are you getting? So citizens, by that logic, enjoy variety of rights. What I'm trying to simply say that citizenship does not mean only some legal rights that you get. Right? It is the set of broadest possible rights that you can have. Right? So citizenship is one area. Now, obviously, this articles 5 to 12 or 11 explore basically that who are citizens, how are they defined, right? What is the importance of being a citizen? In a country or in a nation, do only citizens live? No. There can be tourists, aliens. There are friendly aliens, right? There are adversarial aliens, and likewise, and likewise, and likewise, right? Citizenship also helps us in understanding the dominant obligations of the state. If you classify people into citizens and non citizens, right, the primary obligations of the state may change. It may be reviewed, it may be restructured, but that does not mean that non-citizens will be treated, will be exploited compared to the citizens. It's not true, right? Non-citizens may also be treated equally with the citizens, except for certain rights which are not available to them. Right? So logically, having a citizenship status, as the constitution talks about the provisions of citizenship, right? Constitution technically does not guarantee citizenship. Try to understand. The citizenship that is guaranteed in any political system is basically by law. So if I say citizenship provisions are visible in the Indian constitution, yes they are. Does the constitution directly itself defines and gives citizenship status? No. It gives the power to the parliament. It gives power to the government to now define the provisions for citizenship. So are you saying? That is why we have different modes of citizenship, different modes of defining and acquiring citizenship. So Constitution does not elaborate upon it. Constitution does not guarantee everyone who is part of India as citizenship status. That is why citizenship is to be acquired by law. I'm sorry? So there is always a confusion. Citizenship as a right, is it constitutional? No, it is legal. Citizenship as a definition, legal. Right? Does Constitution provide the provisions for citizenship? Yes. So you have a framework for citizenship under these provisions, right? But is Constitution providing specific guideline, specific rules, specific provisions for citizenship? No. Anybody who is in India, will he be guaranteed citizenship by the Constitution? No. Why? Because citizenship can be acquired by law and can also be terminated by law. Okay, ये बहुत important क्यों? Because anybody who's in the territory, who may be entitled to certain rights, may not automatically become citizen. You may have citizenship status by birth, right? But it can be terminated by law. You cannot have it permanently till your death.
in the constitution, but still it is not like a
See, constitutional right means can you go to the court? Can you go to the, you can go to the court, right? Can you go to the government? Can you go to the court and say, "Ki bhai, government must give me citizenship because I'm part of this country"? No, not necessarily, right? So you can be born with a citizenship status, try to understand, but you can be deprived of it by law. You may not be born with a citizenship status, but you can be given that status with the law. So you can have natural citizenship, inherited citizenship, and you can have acquired citizenship. Are you getting? That is why we say it is not the fundamental right of anybody who is residing in this territory. It's not even the right of those people who claim naturally to be the citizens of this country. Why I'm saying this again and again? Because it is there in the constitution, but try to understand, right? Does it remain permanent with you? No. So the status of citizenship, that is subject to law, right? Citizenship as an idea, as a provision, remains in the constitution. You understood this much? ठीक है. और कोई डाउट है? आज इतना ही रखते भी. आज क्लास, the second class is at 3 actually. Did you get the message? Fine. So our next class is little early today because of Christmas, right? Obviously, some students have to go early, and they should go early, no doubt. You have any doubt? You have no doubt. Fine. So tomorrow we'll do questions on this. We'll read citizenship, then we'll do questions on that, because after that it will become more complicated, fundamental right and this. So where is the theory of natural justice visible in? See, whenever you think of Article 20, right? Article 22, it is obvious principles of natural justice are visible in them, right? Whenever you think of protection of civil servants in the Constitution, principle of natural justice are visible, right? Not mentioned anywhere. See, try to understand. It's not outrightly mentioned, but because we can form administrative tribunals, because we can have quasi-judicial bodies, because we have the provision that through a law we can establish these systems and provide them powers to administer themselves. So from various aspects we see the emergence or existence of natural justice. Right? Otherwise, we say we are procedure established by law or rule of law system. Right? Principle of natural justice is inherent throughout the constitution everywhere. There is no need for special mentioning of that. Right? So every institution in our country, every system in our country follows the fair and just process. Right? People have liberty, people are allowed freedom to uh, get justice, right? By having or by using certain already given means in the law, right? Law does not discriminate, or law is not discriminatory in that sense. Institutions of justice are fair to everyone, accessible to everyone, and so on and so forth. So you can say everything, right? We try to eliminate the conflict of interest. We try to eliminate the corruption from the institution. You see, anywhere. But you can say, yes, principle of natural justice are specifically visible rather than being mentioning, right? It is naturally there. Yes, it is there. No, no. You go to specifically now. See, you go to Article 20 and 22. Read them. You will realize, right? Article 20 talks about what? Hmm? Preventive detention. 22, protection with respect to conviction of offenses. Right? You read them, you'll understand. Right? So no ex post facto legislation, no double jeopardy, right? No self-incrimination, right to be heard, right to have fair trial. All that is mentioned directly. Right? But you cannot say it is only that. If the question comes, you can say yes, it is visible there. But is it inherently part of the Indian Constitution? Yes, it is. Right? See you then tomorrow, right? Enjoy your Christmas. Merry Christmas to all of you. We'll talk about. Let me just. ठीक है चलो